So good afternoon. I assume people have joined the webinar or maybe drifting in as we continue. I just want to quickly introduce the two of us. My name is Kevin Muse. This is my partner, Johanna Sullivan. We are estate planners at Nutter, McLennan and Fish. I understand many of you have watched the two prior webinars, so you've met some of our other partners who've given you insights into some of the initial estate planning things that people think about. I think you're going to find that this seminar is maybe a little bit different in terms of structure. We're going to be a little more free form. We don't have a lot of slides. We're going to bounce around a little bit. And that's really, I think it's a product of the type of stuff we're talking about, because we're going to be talking about things that change and morph over time. The fluidity of the process of the estate planning. And I think you'll see that will make sense as we start getting into examples of what we do and what we want to talk about today. You'll see it's just unstructured because it kind of has to be. So from the prior presentations, the information you got, I think, primarily was in the first seminar, you learned about putting together basic documents. And these are things that address what happens if you become disabled, powers of attorney, healthcare proxies, things like that, and things that take effect if you die. So that's wills and trust. And these are just basic documents intended to cover those eventualities which happen sometimes. Well, the second one, of course, happens eventually. We just don't know when. And then the second seminar, I think they talked a little more about more structural issues and some basic estate tax planning, taking advantage of your exemptions, setting up trusts for minors, things like that. So that's where we are now. This is just a brief agenda here you can see, but if you flip to the next slide, what I think the point we're going to try to make today is, well, gee, you've signed these documents. I've got these wills and healthcare proxies and powers of attorney in place. I'm all done, aren't I? And, you know, maybe you are, probably not. And the basic thing to keep in mind here is the documents are static. You know, we try to make them flexible, but there's a limit to what we can do because they're static documents and they have to react and address your life situation. And your life situation is going to change over time. And we'll talk about that. The problem is when you're setting these documents up initially, we don't know necessarily where your life will go and what will happen. So it's virtually an impossibility to try to address all those things. So at a minimum, what's going to happen is, things are going to change and you're going to need to periodically review your basic documents that take effect if you become disabled or died. And when younger people come in and they have young children, I like to give them a little preview of what's going to happen over the next 20 or 30 years. I may not be here for the duration of that, but when they come in first, they've got 4-year-old kids, 5-year-old kids. Their main concern is who's going to be the guardian, who's going to take care of these children if we die. Mercifully, parents almost never do die when their children are minors. Sometimes they do, but what's going to happen is the parents are going to get older, and guess what? The kids get older too. And as they get older, things will start to change, and you'll start thinking about different things. They'll turn 18, and you'll be thinking, gee, I'm their parent, but I don't know I have legal authority to make decisions for them if they become incapacitated. So maybe you'll have them put together powers of attorney and healthcare proxies of their own. And then they get a little older, and you're going to start think, gee, I'm not worried about naming guardians for my children anymore. Maybe I should name my children as my healthcare proxy and my power of attorney. And that's what's going to happen is your relationship with your children is going to change over time. And your documents need to change to reflect that. So that's on the most basic level. Life changes, your circumstances change. You need to keep an eye on your documents and make sure that they're up to date with where you happen to be at any time. How often do you do this? I don't know, 3 to 8 years. Some people go 20 and they shouldn't go that long, but probably 5 years is a good average. And often those checkup reviews are pretty quick. There's not a big difference between kids being 5 and kids being 10, but 15 and 20, yeah, that's when they start happening. So you'll see that these things will modify over time. So again, that's why I always tell younger people is, you're going to sign these documents. I can almost guarantee these are not going to be the ones that take effect when you die. But they address where you are now And that's a critical thing because we have to address where you are now, and we'll deal with what's coming down the road later. So it's not just the documents. Things are going to happen in your life too. And I consider that part of the estate planning process. So one, obviously, eventually your children are going to get older and they're going to move out, and maybe they need some help buying a house, for example. And I think that's part of your estate planning process, and it's different for different people. A lot of it is based on means, of course, economic means, and in sort of situations where we have more modest means, you may call upon your estate planner and ask, well, gee, should I be signing a guarantee for a bank loan for my child, for example? I think the house is a good example because you can see sort of the variations that happen. If you're a little wealthier, I might suggest maybe you should be the bank and you should do the loaning, and you can do low interest notes, and there's all kinds of stuff we can do. And on higher end things, we can be talking about higher end things. But the fact is, you as a parent can be involved in that process. And then your children will get married, and that raises a whole bunch of things you're going to want to think about, and prenuptial agreements, and it's going to change the way you look at your plan too, and because you're going to be thinking about these new spouses. In my experience, that tends to be the thing that gets people's attention more than just about anything else, until grandchildren arrive. And then they sort of switch their focus. And so when the grandchildren arrive, we may have conversations as part of your planning about maybe you want to help with their education. And again, it's a means-based approach. Less modest means, maybe you're talking about helping out with the 529 plan. More substantial means, maybe we're setting up trust, maybe pretty big trust. So that's what's going to happen, is things will happen in your life. There's a lot that goes on between the time you sign your documents and the time you die, and that needs to be addressed. And I call that estate planning. And again, for different clients in different situations, there are different responses, but that's what we're here for, is to counsel you through the various options that are available. I think the key with all of this, we mentioned the goals up there, is we talk a lot about taxes, at least I certainly do, but that's not what's driving things. You need to always think in terms of what it is I'm trying to accomplish, what are my goals, and then you break us out and we can help with the specific techniques to be appropriate and be tax efficient and all the rest of it. But the whole idea of doing things to save taxes is frankly not really, it's not where my head is, and I don't think it's where you should be at first. You should be thinking about what you want to do, and then we can talk about how to do that. And we're going to talk about a lot of the tax savings options out there because they're interesting and fun, and we can give you an idea of the different types of things we've done. But before we talk about the specific vehicles, there's sort of two overarching concepts that I think are important to keep in mind. And one is what I guess I'll call it a structural issue. The trust is, in its words, it's static, but it's kind of organic. It's a structure, which means it has different relationships in there and roles. There are trustees, there are beneficiaries, all the rest of it. When you're creating this thing, you want to think about how they all interrelate, and that can move over time. So Johanna's going to talk about that issue, which is, again, it's a structural issue. Who are the people involved, and what are their roles? And how do they talk to each other and interrelate? And at some point, is there some baton passing that happens? So that's a critical thing to get right. The other one, I'll talk about the other one. It's the idea of talking to your children about all of this. And that's probably a scary thought for many people, but I'm going to try to persuade you it can be done in an intelligent and incremental way. And at the end of the day, it's going to make everyone's life better, because information is power and conversation is important. So with that, I'm going to hop on mute, and Johanna will talk about these incredibly important structural issues.
Okay, thanks, Kevin. So as Kevin said, one of the big decisions that you have to make is not only what you're going to do for your children, but how are you going to do it? How are you going to structure it? And the right answer to that question depends on a lot of different things, such as what your means are and what your goals are, and where your children happen to be at that particular point in time. So this is something that's going to change over time. But you know, when you put a trust in place, which is sort of our starting point for this discussion, I think, one decision you have to make is who are you going to put in place to manage, to carry out what it is you put into place. And really that's your choice of trustee. And this is true in your revocable documents, those core documents that you went through in the prior presentations that have some, some tax planning in them. But also if you were to put in place an irrevocable trust for your kids, in this interim period, as you start to build a more sophisticated estate plan. So one thing to understand is what are the responsibilities of a trustee? And that, the trustee is the person who's going to make the decisions about how the assets you put into the trust are managed and how they are spent. So both how are they invested, and then what do your kids get to spend the money on? So what is it important? What are the important characteristics of a trustee? I generally say you need someone who's able to understand the asset management and investments and maybe it's whatever else you might be putting into the trust, but probably at least as important is that you need somebody who shares your values and who will understand what it is you're trying to do and what you want to do for your kids. The idea being that this person's judgment is going to step in and be a substitute for what you would do if you were making the decisions. And sometimes, one question we often get is, can the guardian be the trustee? The answer to that question is yes, the guardian can be the trustee, but it's not always the best approach because, it might be that the reason you chose someone to be a guardian, is you want someone perhaps with different characteristics or qualifications. And so at a minimum, I would often recommend that you have someone in addition to the guardian so that there's some sort of balancing. The guardian's going to be the person making decisions about where you live or where your children live and where they go to school and those sort of daily life decisions. And the trustee is how are these financial assets going to support that? Now, this is in your revocable documents. When your kids are minors, you have to have an independent trustee. So that means someone who's not a beneficiary of the trust, and who, again, if you're not around, you really need someone who's going to be able to make those decisions. When your children get older, it starts to shift a little bit, and we assume that the goal is that you want your children to be as independent and responsible as possible. And so you want to empower them. You want to have documents in place that empower them to do that, and so that they can understand that that's the expectation. So sometime after they become adults, typically in their 20s or 30s, we would recommend that you allow your children to become a trustee, and that gives them a seat at the table, so to speak, so that they are involved in a more official capacity as a trustee, and not simply as a beneficiary who's receiving direction at the mercy of the trustee, or decisions at the mercy of the trustee. And it's a good opportunity for them to start to learn about the structure and what it means to be a trustee, and the responsibility of having of managing a trust. And then as they continue to get older, you might shift things further and allow them to become the sole trustee. And there are as I like to say to people, there are sort of there can be circumstances where that's not appropriate. And there can be good reasons and there can be bad reasons why that's not appropriate. Sometimes you have a child that is so wealthy independently and so successful that they want to distance themselves from any additional, family wealth, and that can be a good thing. The other is if you have a child who's a professional, let's say a physician or something, and they have specific creditor concerns, you might want to be sure they have an independent trustee so that they get sort of the maximum creditor protection. The flip side of that is that if you have a child who doesn't become responsible and independent in the way that you hope they will, they might just not be capable, frankly, of being a trustee. And so, as the important thing to know is that there are these different approaches and these different options that will be appropriate at different times, depending on, again, on the age of your children and their particular circumstances. And so as you put a plan in place, you always want to keep an eye on, are the people that you named when your children were 5, when you did it the first time, when you take another look, 15 or 20 years later, are those still the right people? And as you do the planning in the interim, you're asking those same questions. Are these the right people? And how do we build in the options to adjust as time goes on? Kevin?
Thank you, Johanna. I might add one thing to that, and this is a little hard to articulate in words, so bear with me while I go in a couple of different directions. As I mentioned, the trusts are written, they're sort of static, and it's hard to anticipate the next 30 years in a document, but to some extent you sort of have to. And by this, I mean, I mentioned baton passing, and Johanna was talking about at some point possibly letting the children become the trustees themselves. And the idea behind that is, well, they're completely actualized, they're good people, they know how to run things, but having a trust, so they don't want someone looking over their shoulder. On the other hand, having the trust can provide them with benefits that they enjoy and like. As Johanna mentioned, if you're subject to potential malpractice claims, it's nice to keep it in trust because it's protected. There are tax reasons why it would be good. People really worry about divorcing spouses, and that's a factor as well. So we can certainly have a situation where we have a trust, not because the child needs it, but because it's useful to them. And that's an important distinction. So who makes the decision on when that happens? Well, this is where it gets a little bit interesting. You really need to rely on the clients to come up with a plan, a structure that works for them. So if you have 10-year-old kids, and I'm sitting there in the room asking, well, do you want them to take over when they're 40? Well, I don't know. We have no idea how the kid's going to be at 40. So we can work into the plan a mechanism by which the children can take over at age 40. But since we don't really know much about them and their abilities in this regard at that point, we probably want to structure the plan so that transition decision is made by someone other than them. And by that, I mean, we could start with a default of a professional independent trustee and leave the trust flexible enough that at some point that trustee, if they thought it appropriate, could step down and appoint the child as the sole trustee and let the child go with it. So it's a question of who gets the ultimate call on the decision. On the other hand, if your kids are 25, you have a pretty good idea where they're going to be, but they're not quite ready, then we will more often build into the document, assuming you want the lifetime trust, we would more often build into the document a provision where the child at a particular age, 35, you fill in the blank, they get to say, I don't want the independent trustee anymore. So that's just an allocation of the ultimate decision, but the structure is the same. So and again, what happens over the years, the kids do get older and the parents are, well, gee, I know where they are now. I don't want to rely on the trustee anymore to be in charge of that transition. My kids are 25, they're doing great. I'm going to change the plan so that now they get to decide. And that's how that evolves over time. So the other major sort of conceptual point to think about is bringing your kids up to speed on all this. So they're doing their own thing, and you're raising them as your children and teaching them your values, et cetera, and they're growing and you're keeping an eye on them. But in terms of all this stuff, I don't think we can just assume that they will sort of figure it all out and there'll be this absorption that happens. I think we need to help and guide them along the way. So in my view, the best thing you can do to prepare for a smoother transition is to involve your children along the way. And I mentioned when your kids become 18, you're no longer their guardian in the sense that you can't make if they're in a coma, get in a car accident, God forbid, and you're the parent and the child's 18, you can't make the medical decisions because you can't. The child's an adult. So if that situation arises, you need to go off to court and get appointed as a guardian to make those decisions. So, I know this, and this happens very rarely, but if it does, you really want to have the mechanism in place. So what I tend to suggest to my clients is, when your kids turn 18, this is what happens. Why don't we have them do a power of attorney and a healthcare proxy to mom and dad, naming the parents, and then we don't have to go to court if something happens, and it almost certainly won't, but it's just prudent to do this. And by the way, just because it's easier, why don't you bring them into my office and we'll sit around a table and sign these documents, and I can talk to them a little bit. They can see who I am and what I do, and we can talk about your sort of estate in general terms. And this is a way to start bringing them into the process. My theory is, and I've been doing this a while, I think it works out pretty well. If you show that you trust the kids and you want to engage them, and then they're going to want to learn, and they will learn. I remember I took my kids are 15, so the jury's still out on them. But I remember we were at Home Depot once upon a time picking up some stuff, and I saw the key duplication stand. They were about 13 at the time, or maybe 12. And so I said, gee, would you guys like house keys? And so we went and made them house keys and got them a nice little key holder. And you could just see their eyes light up. They were just brimming with pride that Dad would trust them with a key to the house. And so hopefully I'll be rewarded in a proper way. One never knows. But I think my point is, people like to rise to the occasion. If you give them a chance, they'll learn. So when they come in at 18 or 19 or 20 or whatever and sign powers of attorney, we're not going to be going through great detail about what's going on with the parents' estates. We're going to talk in general terms. You guys are young, there'll be a trustee involved. It might be me. We'll be talking about how to take care of financial matters if this happens, just to give them a comfort level and to get them used to the idea of working with this. So again, the point is, it's just not going to happen by itself. This is done in a slow, incremental way. This takes decades to do. It's fine. I start slow. I've been doing this a long time. I've seen how things shake out. So we start little, things speed up. There'll be other touch points that will happen after the child's become a quote adult. Again, they'll go buy a house. And I often get pulled into that discussion. There are discussions about getting bank loans or loans from the parents and all these different things. And we can talk about the economics of it. It's really, gives them an engagement and lets them get their say. And then we can show the advisors, that is, that we can help them along the way. And then they'll be more likely to seek our advice after their parents are gone. They'll get married at some point. Again, it's a point of discussion. So I'm happy to talk about prenuptial agreements, and people can do them or not, but it's important, I think, for them to know what they are and what they do, and how it may be something they're interested in or not. But you want to have a discussion. And when they have children, it gets a little more interesting, because then we're having discussions about providing potentially for the grandchild's education and different ways we can do that. And one common thing I like to do is I'll have the grandparents set up a trust for the grandchild's education and have the children be the trustee. Here's a way to get in there and get the children used to being trustee, not for themselves, but for people they care about. And it's good practice, if you will. And again, we're showing them that we're trusting them. They're their children. They should be running the show. But we're helping them with the mechanism to get this in place. Just sort of at a different point, this river flows in both directions. So I'm talking about trying to convey the information to your children, the next generation. And I guess I just asked the question if you've all done that in the opposite way. I find that people often hesitate to talk to their children about what's going to happen when they die. And if you're older, 40s, 50s, and you have older parents, if they haven't had that conversation with you about their estate plan, I think it's probably in your interest to have it with them. I often will go to the parents of my clients, particularly the wealthier ones, and talk to them about the sort of structure that would be useful to us to have. And it may in fact be a trust structure that the parents weren't thinking of setting up, but that my client finds would be useful. Again, it's sort of a tax planning option. So you need to have that conversation in the upstream too. And I joke with clients, I don't want the first time your children meet me to be at the funeral. I want them to have a comfort level with me prior to then. And if we're all in a room together and their parents are saying, this is Kevin, we trust him, we work with him, he's going to be helping with things, then that's going to go a long way. I think I mentioned Johanna the other day. She's from California, so I can talk about Hollywood, but I see these movies where they do the reading of the will. I've never done one of those, and it makes me cringe every time I see it. How these surprise people. It's like, oh, this is not going to end well. And of course, it's the movie, so it doesn't. But the point is that's a mistake to just drop things on people as a surprise. Anyway, I'm rambling a little bit there. So again, major structural issues, primarily a trustee issue, and at what point we maybe pass the baton to the children as trustee, and an information sharing thing. Getting the children involved in the process and realize it's fine. You're going to do this. Every couple of years, something's going to come up. It's accretive. It's a lifelong process, but it's one that cannot be neglected. Okay, so those are the general overviews. I think we're going to talk now sort of one-off things we've done in reaction to specific situations. A lot of it is tax-driven, and that's just the nature of the beast. But when I say tax-driven, a lot of it is tax-heavy in terms of content, but it's driven by other things. So I'll just throw out a couple. I think we'll bounce back and forth on this rather than just having me drone on. But having done this for a while, I see how this works in terms of the numbers. So if we want to plan for a grandchild's education, and the grandchild's 2 years old, again, for people of more modest means, maybe we just set up a 529 plan, have the parents be the participant or owner or whatever it's called, and you just send some checks, $5,000 a year. You could put in, you can put in more than that, of course, if you want to. If you're a married couple, you can put in I think 15,000 times 5. Yeah, it's like 100. I forget the numbers. It's a fair amount. But if you want to do something a little more substantial and you have more capacity, you might think about putting in up to $30,000 a year into a trust for the grandchild. And that, as some of you may know, that's the annual exclusion amount. And you can do a little spreadsheet to see this. In fact, if you put in $30,000 a year for 20 years and it grows at 5% a year, which is pretty darn modest, it's over $1 million by the time the grandchild's coming out of college. And that's plenty of money for a down payment on a house, to starting a family, all the rest of it. It's really easy to do, but it's just, it's compounding. All of this tax planning stuff, start early and be patient is the key. So I just throw out that trust, just a simple little trust for a grandchild, for their parents to run, that's going to have a substantial impact in the end without much effort on our part. Maybe, Johanna, you want to sort of bounce back and forth with some examples of things we've done?
Sure. So I would say that the next one is, if you have, anything you have that looks like it could potentially, grow in value, something that's relatively low value. And sometimes it's, stock in a company. If you have stock in a private company that looks like it's going, that's going places, whether as a founder or as an early employee, take a couple of those shares and put them into a trust at a low valuation. And as those grow, all of that growth is outside of your taxable estate, meaning that it won't be subject to tax later on at your death. Now, if those shares, if this young business goes bust, you've lost nothing, because if you still own those shares, they would still be worth nothing. And if they increase significantly in value, then you've hit a home run from a tax planning perspective, and you still have, as Kevin would say, you're still rich because you only gave away a sliver of what you owned to begin with. And I've seen this, just to share a real life story with a client who's the CEO of a company that was founded in 2009, and around 2012 he gave away about 10% of the stock he had in the company. And just last year, the company was bought by a private equity fund. And now each of his children has $1 million in trust, and used up essentially no estate tax exemption. And it's all in trust. His children are responsible adults, but they're going to keep it in trust for the foreseeable future because they don't need it right now. And my client has, still has more than enough money to live his life and travel and do all the things that he wants to do as he gets ready for retirement.
So I have similar situations to it. It's fun. I mean, obviously, it always doesn't happen, but it's my favorite one was this was I think we did this 25 years ago. 50 cents a share when we set it up. It was still privately held. I think it was $100,000 total value, and we did that. I think maybe 5% of the founder's stock. Stock's trading recently at $260 a share, so you can do the math. It's interesting. You all may be in a better position to actually get that in front of people, because time value of money counts for a lot. You take a little chance on this one gift at the beginning. It's going to hit or not. If it does, you're going to be done in many cases in terms of providing for your children, because you'll have these big trusts set up for them, and we'll figure out how to get them comfortable with running them eventually. And your attention may turn to other things like charitable giving, which often happens. It's not hard to do. This is easy stuff. It just requires foresight and patience, which is back to the point. When you're doing the tax planning, through the words up there, you want to be proactive and opportunistic. So if you have a chance to be with someone who's founded a company, they don't always pull the estate planners in. But if we get into that room, that's the first thing all of us are going to say, can we do a little gift? Because why not? Take a chance. And 30 years later, they'll be thanking us, or not. But it will never be a problem if you do that. I give another example. It's always, you have to be specific on the situation. So I had another client. This was interesting. It was actually during the interview when she was deciding if he would hire me to do his estate planning. I saw a funky asset on his balance sheet. It was a Dutch stick tomb, which I didn't know what it was at the time, but I knew enough about the structure of it to realize there was a great opportunity there. And I begged him to hire me, please, just so that I could do something with that one. This was an asset that was very hard to value, which made it not something you want to make an outright gift of, and it had a tremendous cash flow potential. So on that one, we did what we know as a GRAT, Grantor Retained Annuity Trust. I set it up 10 years ago. The gift was $600. He still has to survive until the end of October for it to work, because our 10 years isn't fully up. But at that point, he will survive, and we'll have $30 million in that one. So that's just a big home run. I think he put about 20% of his interest. So if we're not in the room, if we're not talked to, again, for people with more substantial means, then we're not going to be there to point out these things that are simple to us. And then what will happen is the company will go public. There'll be a lot of money, and then they can come talk to us. But we'll miss some opportunities to do some things along the way.
So another thing we often talk about is what can we do with real estate? And real estate, again, is another asset that, tends to go up in value. And, maybe I should take one quick step back just to make sure we've explained really what the strategy is that we are talking about with all of these things, which is, I think you talked last time a little bit about how the estate tax laws work, and every person has an exemption amount, which is currently it's 11.7 million for federal tax purposes. And you can use that at death. If you have $11.7 million at death, you can pass that amount on to your family and pay no estate tax. Once you get over that amount, you have to pay an estate tax. And that number, that 11.7, it goes up and it's probably going to come down. So that's not the number itself is not the thing to focus on. But you can also use up that exemption while you're alive by making gifts. And so what we're talking about is sort of leveraging up that ability to transfer by transferring something that is low in value as a gift while you're alive, and then and using up that lower value of your estate tax exemption. And then all the growth that happens after that transfer is outside of your taxable estate and does not count against your exemption amount. So just to take a quick step back, that's the general strategy or structure that we're talking about with these tax planning opportunities. And so another asset that people like to transfer to children is real estate. And of course, real estate, at least these days, seems to be something that goes up in value. And so there are different things that you can that you can do with it. One is to bifurcate or chop up the ownership so that you don't own 100% of it, but maybe you own a fractional interest, even just you and your spouse owning it as 50-50 tenants in common. That gives you the ability to take discounts on valuations when you transfer it. And then if you do want to transfer it out of your name, there are a couple different things you can do. One is called a QPERT, which is you transfer it and you retain the right to live there for a certain period of time. And as a result, the value of the gift that you've made is reduced by the present value of your right to live in the house. And what exactly that present value is depends on the interest rates at that point in time. And assuming you survive for that period of time, at the end, the house transfers out of the QPERT and to your children, or whomever you've selected as beneficiaries, or a trust for their benefit, again using up a reduced portion of your exemption. And then you can do things like pay rent to your children, because you don't own the house anymore, but you're still living there. And by paying rent, you're not making any more gifts. You are paying what is owed. So you're getting more assets to your children, but you're not using up any additional exemption. You can do it, as a direct transfer, which I'm actually helping someone do that right now. He's going to transfer his house to a trust for his children, and he's going to start paying rent to them. The idea being that he won't get a discount on it necessarily on the transfer, but it's a property in a location that even with current high priced real estate, he thinks is going to keep going up. And then he'll pay rent on that expensive home and keep getting more assets out of his estate.
I saw a couple of questions here, and maybe it's worth jumping on those just to take a little break from the examples. But one of the questions is, what's the analysis for deciding whether or not to name a trust as a 401k or IRA beneficiary? I think the short answer is it depends on the beneficiary's situations. So it's complicated to name any trust as a beneficiary of deferred comp of a qualified retirement plan. You can make it work. the trust has to be a little bit complicated. The tax brackets may not be the best. So my general reaction on that is if the kids are old enough, even if they're not old enough to have control of the full trust, if the retirement plan is just a slice of your estate, I tend to name the children as the outright contingent beneficiaries. So you name your spouse first because it just makes sense for a whole host of income tax reasons. And then at the second death, you'd have it go to the children outright. And you know, at what point you do that depends exactly how big it is relative to your estate and in absolute terms, and how old your kids are. But to be honest, if the kids are 25 or more and it's not more than a quarter of your estate, I tend to push towards the outright designation. It's just simpler. If the kids are little, you don't have a choice. It has to go to the trust. Again, it's not likely to happen that way because they're going to get older and then you'll change that part of your estate plan. But as a default, you know, if they're under 21, you're going to name your trust as the contingent beneficiary. And then the key there is just to make sure you've hardwired into your trust the proper language to make it work. For whatever reason, the IRS loves to make this complicated. There were some recent tax law changes which take away what was called a stretch IRA. They're gunning now for IRAs again in the proposed legislation. But under the new rules, basically after you and your spouse have died, it has to come out in 10 years. And that rule applies whether it goes to a trust for your children or to your children outright. The difference between the two is if you do it via the trust, you get to add more complication to make it work. There's a second question about restricted stock, giving it to a trust. And the short answer on that one is I wouldn't really do it. The IRS has a revenue ruling. Oh, that's an old one now. I think it's about 20 years old. That basically says something that hasn't vested like that isn't, quote, property. And if it's not property, you can't make a gift. I think it's wrong. I think a lot of other people think it's wrong. But if you want to do something that's contrary to a revenue ruling, you need to disclose it to the IRS and make it clear that that's what you're doing. So, you know, I tend to shy away from things that are scary or complicated and look for some other opportunity. So the short answer is I don't think that is something I would want to do, but I'm sure people do it. I'm gonna go sideways in terms of being opportunistic. This one might sound a little ghoulish, but it's the kind of thing we do. You know, we can help the family maintain their assets and get advantages. So when the exemption went up a lot a couple of years ago, I had a client who immediately wanted to use the rest of his newly found exemption. And, you know, I put the brakes on a little bit and tried to think of a more creative way to get some leverage out of it. And I knew that his mother had been diagnosed recently with lung cancer. She was quite senior. She did not have a big estate. So, you know, you sit and think about it, and there's an opportunity here. He wants to give some money to a trust for his children, fine. He has a mother who doesn't have an estate of her own, and we can take advantage of that, particularly knowing she's not well. So I'll tell you what we ended up doing. It was completely legal, not aggressive at all, but kind of cute. We had him take about $3 million of his newly founded exemption, put it into a trust for his kids, like he was planning to, but made his mother a beneficiary, which we really weren't thinking we'd have to give her money, but it's nice to have the backup if she needed support. And we set the trust up so it'd be included in her estate at her death. And under the law at the time, what that meant is he could set up the trust. It's a gift. He was going to make the gift anyway. He put in very low base stock. And when she did die about 12 months later, maybe 16, a couple of things happened. The trust was includable in her estate, which you may think is a bad thing, but it's not, because she lived in a state that didn't have an estate tax, and the federal estate tax exemption made the tax zero. We got to step up in basis on the stock because it was includable in her estate. So we made a lot of capital gain go away. And then we had her allocate, well, we arranged for her generation skipping exemption to be allocated to the trust, which allowed us to basically set up an additional pot that could go on for future generations and not be taxed with the children's debts. So it was just an opportunistic thing. Again, client wanted to use his exemption and set up some funds for his kids. And by calling me and asking me about that, I was able to put some bells and whistles into it that got us a lot of extra benefit. Again, not at all aggressive or over the top. It's just something that's allowed under the tax laws. Back to Johanna.
I'm looking to see if, I think maybe we'll move on to the next slide there. To talk about, some of the things that we think require some special attention as we do this, planning. And as Kevin and I were preparing for this, we did, have a little bit of a back and forth about, what are the things that we see, potentially cause problems. And it's true in very large estates as well as more modest estates. The number one thing that, or I should say, one of the top things that we see causing trouble are really the tangible property and how it gets divided up among children. And that is, to the point of, as I had one recently where the children were fighting over their mother's clothing. So it's not necessarily a value issue, as it is, it can be a value issue, but it's also, what are the actual things that are important to your children and family? What are they going to be attached to? And so, sort of getting back to best practices, it's important to have a plan in place and to do your best to anticipate what are the items that are going to cause issues. And so this comes back to communication with also with your children about what it is that they care about, what it is that they want, and what is important. So that's one, and there are different systems you can have in place for dealing with those things, but I think raising it as an issue is important. Another is a vacation home, and vacation homes are generally, different from primary homes, but because there's an emotional attachment to them that tends to be a little bit different than other real estate. Sometimes it happens with the family home as well, but oftentimes, at least some portion of a family wants to keep a vacation home. And if that's going to happen, there has to be a plan in place as to, how is that actually going to work? And we can set up a structure with a trust or an LLC, a business entity. But most importantly is that some terms are agreed to as to how the vacation home is going to be used and how it's going to be paid for, including how somebody who doesn't want to own it will be able to get out of owning the family home. And so, it's important to have a plan in place, and to communicate with your kids about, to find out what it is they want and what it is they are capable of. It's oftentimes the case that there's at least one child who says, I don't want to own this real estate, I just want the cash. And so, how is that going to happen? Also, who gets to use the house for the first 2 weeks of July, and who gets to use it for the second 2 weeks of July? Those types of questions can cause a lot of tension between siblings. So addressing those questions sooner, and bringing everyone to the table, earlier on, obviously that we're talking about with adult children, is a good way to approach it, so that a plan can be put in place that's going to make sense for everyone when the time comes. Family businesses create a whole host of, getting back to both opportunities and sort of issues between siblings that need particular attention. You know, with tax planning strategies, it's, you know, a business presents a lot of opportunities to, again, divide it up into smaller pieces and take discounts on the valuations, and transfer it out to children. But there's more to it than that, because if the family wants to continue to operate the business, there's tax planning that's important, but there's also a continuity question as to who's going to run the business, who's going to own the business, and those aren't always the same, you know, aren't always going to be the same people. And how is that transition going to occur? And so, you know, at least in my experience, and Kevin, you should chime in, you know, that's something we always get the business attorneys involved as well, as we're working through this, because it's got to make sense in your estate plan, and it's got to make sense on the business side too. And again, if there's somebody who just is going to want out, how is that going to, how will that be structured? How will that person get out in a way that's going to work for both business and for them?
I might add there, and it's an interesting point. So, you know, the issues with the businesses and the real estate is they're hard to divide. So just to be upfront about it, I've been through a lot of this, and Johanna will back me up on this. When the senior generation has died and suddenly the 60 or 65-year-olds sitting around the table, the children, start looking like your 15-year-old daughters, it's interesting. I have 3 siblings. We will do exactly the same thing. So I'm not criticizing. I think it's just human nature. Siblings behave with respect to each other in a certain way. And when the parents aren't there, it really makes a difference, because that moral, that gravitas that was there, that people obeyed, even into their, you know, 60s and 70s, is just gone, and they're left to revert to their former selves. So, and that's where it ties in with, if you ask an estate planner, you know, should I have my daughter, who's more competent than my son, be the trustee for my son when I die and have a share for my son? I think for most estate planners, you'll get a pretty strong eye roll. The last thing we want is for siblings to be connected any more than they need to be. They should be separate. But if you have a piece of real estate that they both want to use, or a business that they both want to have an interest in, then you're stuck with that. So that's what you should have in your mind when you're thinking about this planning. Is I've got this sibling relationship, which we all know is difficult. How do I manage it? And at least in my view, on the real estate, when we're setting up these structures, I tell people up front, there's a 50-50 chance it's not going to work at all, because it's just the way it is. If someone wants to bust this up later, they'll figure out a way to do it. It'll be uncomfortable for everyone. We'll have to buy them out. I mean, something will happen. But my plan with that is, if I get all the children actually engaged in that discussion and have them negotiate and agree with their parents the terms of this arrangement, this kind of a buy-in. I mean, look what happens in Washington when they do things unilaterally. It just doesn't last. Things change all the time. But if everyone has a seat at the table and gets some portion of what they want in there, they're more likely to follow the rules later. Now, let's go back to, it's like the game when you were in kindergarten, you learned everything you needed to know in kindergarten, you all agreed on the rules of the game, and you said, okay, and then you played the game and something happened, you didn't like it, but you know, you agreed to it, so you kind of go by it. It's the same at any stage in life. The business is interesting because your life is dynamic, but sometimes you have kids working there and kids not working there, and the kids working there thinking, gee, why am I making all this money for my siblings? And the kids not working there, gee, I'm at risk because someone else is running the show. It's not good. So you just need to have the conversations with people and make sure that their views have been brought into the arrangement. You can have buy-sell agreements and put rights and call rights and all the rest of it. Give people exit strategies. But you're working off the dynamic that it's sibling relationships can be difficult. That's the bottom line. And so are we doing okay in time? Oh, no. We have more questions? Yeah. Okay.
And I apologize. Something just happened, and so my screen sharing off. But
So it's interesting. I just see a question from Scott about, maybe that was in response to what I was saying, or maybe I said it before he asked the question. Are children as co-trustees okay in the right situation? So from my view, it depends where we are. So if people get older, and at some point we realize, gee, if I die and my husband survives me and he's old and feeble, maybe I don't want him running the show. Maybe I need a trust for him to protect him. And in that case, I think it's a good idea to have children co-trustees if you have more than one child, because they're trustees for their parent. And I think it's a better arrangement because they have a common goal, taking care of dad, and they don't feel that either one sort of is in charge of that. So they're working together. I think that works sense. Obviously, this all depends on the particularities of the family situation. Once you have both died and we've gotten to the point where there are separate shares for the children, and sometimes, by the way, we keep everything in a single bucket until the youngest child reaches a certain age, like 23 is common. The theory being we can pay for all the sort of educational expenses off the top before we divide. But at some point, the kids are going to be separated, and we want that to happen. And at that point, occasionally I will have a sibling be a trustee for another sibling, but it kind of cries out for it because I have a sibling who just can't manage things, and they know that and accept that, and they trust the sibling. But it's short of something like that, I would be really nervous and frightened of having any sibling be a co-trust, any kind of trustee for the other child, for the other sibling's trust. Siblings love each other, and they're the most likely to stick with you until the day you die. It's true, I know that, but they're your siblings, and they know what buttons to push, and there's a rivalry that happens there. So again, it depends on what your family is, but that's not something that I think tends to work out well. So,
A couple other, we have a little bit of content left, and I don't see any more questions, so I'll keep going. We had a couple of other what we were calling special situations to go through. One is, what do people who don't have children do? We've spent all this time talking about, how to plan for your children, and in some ways it's both easier and harder, because you can do whatever you want, frankly, if you don't have children, and of course you can if you do have children, but most people want to provide for their children. So the question for someone who doesn't have children is who are the people or the organizations that you want to benefit? I mean, what I see most often, frankly, is people who want to provide for other family members, maybe nieces and nephews, sometimes a sibling who might need some help, and also for charities. And sometimes it's to the point of setting up a foundation, a relatively large, if there are enough assets, a foundation can be a good approach. And sometimes it's just, that your favorite causes and favorite organizations. It can also be harder when you have so many options. Decision making becomes more challenging. But it gets back to what Kevin said in the beginning about figuring out what your goals are, and what's important to you. That's really what this is all about for everyone.
And those do change over time. So I don't want to give the impression, by the way, that it depends on the clients. I do have clients who I talk to every month or two, but they're unusual. So most of the times, so the average, you're talking to any particular set of clients, maybe every 3 years, and sometimes there's a real quick one, just something came up, they have a question. But we try to reach out to our clients from time to time too. Again, it's a process. Things evolve. You have to some extent, you're reacting because things happen and then you react to them. But I think you want to react in a proactive way, if that makes any sense. It's anytime you see something happens that is sort of a touch point, it's a good chance, instead of thinking this is a crisis I have to deal with, it's more like, maybe there's an opportunity here. The Chinese character for crisis I think is a combination of two radicals. One is the one for opportunity, and the other one is for danger. It says it all. So that's when I say be proactive in the reactive situations. Like, okay, well, here we have a situation, but is there something we can work with to bring this to our advantage, consistent with the client's goal? So it's fun. That's the fun part for me of the work we do. But it's not just sign the documents and then I'll see your kids at the funeral. So, all right. Well, I guess we're kind of hit up just over the time. I don't see any more questions. I think we answered all of them. If people have stuff that occurs to them afterwards, it always does happen. Feel free to dash off an email to Johanna or I. We're a little crazy these days going through the 800 pages of the proposed tax law changes. There aren't too much in there. There's not too much in there that, in terms of length, that impacts the estate planning stuff. But they're doozies. Whether they'll actually get passed or not, we don't know. And that's just as an aside. They change the rules constantly, and the stuff that we do to accomplish the client's goals have to change too. And it's always evolving. It's kind of a constant tug of war. It's hard for them to keep up with us. I'll just tell one story. This is the way I describe to clients. I have bird feeders in the backyard, and I really try to keep the squirrels away from them. And I think I'm smarter than the squirrels. I really think I am. But it seems no matter what I do, they eventually get to the nuts. And what it boils down to is I am smarter than them, but they have all the time in the world. That's all they worry about is getting those nuts. So I can't keep up with it. And it's the same thing with the relationship between the planners and Congress. There are a lot more of us than them, and they decided to make the system complicated. And as soon as you make a system complicated, you open up the path for opportunities for people. So that's a little bit of a speech, but I'm just pointing out that whatever happens, there'll always be something there'll always be some potential thing that we can do to help people out. I just don't know what it is at any particular point in time, because I don't know what the future is going to bring. Okay, with that said, thank you.
All for coming.
Okay, bye-bye.